such a very limited circumstance.
Thank you. Senator Paul Bradford.
Thank you very much. Thank you, Mr. Hare. And the first thing I want to say to you is to commend you for making it very clear at the start that you come here today as what you call part of the campaigning organisation. And I think, you know, if all groups who presented themselves and all witnesses were as frank and as honest, I think it would add greatly to the honesty of the debate. So thank you for telling us where you're coming from politically and where you want the legislation to travel. Now, on the point, Mr. O'Hare, of your contribution,
Sorry, not Dr. Brady, not Mr. Hare.
Sorry, Dr. Brady. On the point of view of point number 5, you argue here that the government must now, at an absolute bare minimum, and I think you're saying that in a kind of legal fashion, that as a bare minimum, we must legislate. Now, I don't have your legal knowledge, but could you please clarify or assist us to clarify the position arising from the European Court judgment? My understanding is that the obligation on the Irish state is to provide clarification. You were saying that as a bare minimum we must legislate. Is that your opinion and obviously your preference? What is the actual legal impact of the judgment? My understanding, and I've heard it from many people, is that the state is obliged to provide legal clarification. You are stating here that we are obliged to legislate. I appreciate it may be your preference, but could you please let me know what is the actual legal position? I would be glad of your observation in that regard.
And may I just at this juncture just to acknowledge the presence in the gallery of the former member of the House and the Minister Gemma Hussey in the gallery. You're very welcome. Senator Walsh.
Thank you, and indeed could I just echo what was already said and compliment you. I think you made an honourable and professional contribution here to us. I'm well aware of your advocacy on the pro-choice side. I think you acknowledged that, which was, I think, an honourable thing to do. I'm also aware from your accounts that you obviously, I think over the last few years, you've received something between 7 and 8 million from Chuck Feeney, and I know that comes with conditionality as applies to other groups that have received it. And I'd like to acknowledge that. Would that other group that have come before us this morning and yesterday would have taken the same professional approach as you have taken? Unfortunately, they didn't. Can I just ask in relation to the point you made? Yesterday, you talked about the C case. Would you agree that the European Court of Human Rights allows, a relatively broad range of discretion to countries in dealing with it, and certainly from a time perspective, they don't rush countries into taking positions which would be against the wishes of that country? Can I ask as well, yesterday we heard from the masters of the hospital that the C case could have been very adequately dealt with under normal procedures within their hospitals, in the way they normally deal with women who are in remission from cancer. If they present in a pregnant condition, there's a mechanism for dealing with that. So therefore we can, and could we not answer, if you like, the concerns with regard to the European Court in that regard, where they've actually acknowledged in their judgment that our position, constitutional position, is in fact fine. Secondly, can I ask you in relation to the X case?
Thank you.
Because you're strong on the X case. Yesterday we had 97% of diagnosis for or predicting suicide are false positives. Therefore, if we legislate for the X case, we do so knowing that in 3% of the cases, the person would probably have gone to commit suicide, and therefore it complies with the spirit and the law of the X case. But we equally now know that in 97% of those cases, we're actually going to abort healthy babies who are entitled to protection under our present constitutional position, simply because suicide ideation isn't able to be predicted with any degree of accuracy.
Thank you. Your time is up. Thank you, Senator Healy-Ames.
Chairman and Dr. Brady, thank you for your.
I want to get out of respect.
Thank you for your
presentation.
Thank you for your presentation. Do you hold a different position on fetal abnormality as opposed to fatal fetal abnormality? And I'm asking that for a specific reason. Medics do deal in probabilities, as they've told us here yesterday, and they can also get it wrong. And I'm very conscious of a meeting with a mother recently who, while living in the UK, was told that her pregnancy, she was carrying twins, that they were, the best way I can recall the way she described it to me, they were the next stage to Siamese twins. And she was advised an abortion on the basis of fetal abnormality. She returned to Ireland. She decided to carry those babies to full term. They're now happy, healthy 6-year-olds running around in a school playground. That's the way she described it to me. Now, a changed legislative context changes how we behave and how we think. And it can also bring undue influence on a pregnant woman. How would you say that that woman's rights would be infringed if we had the legislative context that you are proposing in this jurisdiction? And do you accept that there is, if I could finish this sentence, how would you respond to the evidence as well that for women who carry babies to full term, that who may have fatal fetal abnormalities, that there is a healing in that? And what about the rights of those women in that context?
Thank you, Senator. I want to get Deputy Turbine and Senator Murcoo in, if I can, please.
Margaret Cahirlik, and I just want to welcome as well the two individuals who have come before us today, and I'm very impressed by the engagement that they have made with the committee, and I think it's important when you have different views that people are treated with respect. Just with regards, one of the key points of the debate was touched upon by Senator Crown, and that's the issue of personhood and when personhood begins. In other words, when does a human being achieve human rights? And you said that there was a distinction between the unborn and the born with regards those human rights. And there would be many people in the state who would have the view that your rights to life shouldn't be dependent on if you have a disability or not, and that your rights to life shouldn't be dependent on whether you have a fatal illness or not. In what area of the Constitution can, in your view, does the distinction allow for a different treatment of those two specific issues amongst unborn children and born children?
Definitely. Senator Murcoo, very briefly.
And likewise, I'd like to welcome the representatives of the Irish Council of Civil Liberties, and indeed to thank them very much for the manner in which they have engaged with this committee, and also to help to inform us, and by extension perhaps the general public as well. The question I would like to put to you again comes back to the rights of the unborn. To what extent has the Council considered this in their deliberations? And do they, in fact, have a specific policy in regard to the unborn, in the same way as you've done such an exceptionally good job in relation to expectant mothers? I'd like to put that to you. Secondly, do you believe that the envisaged legislation, insofar as we understand it, is too limited and perhaps might even be inoperable? Now, I noticed that Mark Kelly of your council, speaking last month, said that Ireland should seize this opportunity to have a thorough overhaul of the antediluvian laws relating to abortion. Is that the position as well of the council? And are you also saying that there should be a much more liberal abortion regime, and that abortion should be there as a right? Is that the position of the council as well? And I would like just to remind people that the medical profession yesterday stated that they could not cite one specific case of a maternal death. Therefore, to what extent have we antediluvian laws, or are we actually questioning the medical profession?
Thank you, Senator. Dr. Brady.
Well, thank you very much. To go through those questions in order, certainly in relation to the question raised by Senator Bacic in terms of the decision-making process, certainly we would endorse the expert group's report in relation to requiring 2 doctors at the specialist level. I'm conscious that there was medical evidence given by doctors that in terms of reaching their diagnosis, they often require consultation with others. I don't think we want to impede that, but again, having regard to the ECHR case law on this, the key criterion is timely. So a requirement of more than 2 doctors in legislation, I suspect, may cause a risk of delay, which would fall foul of Article 8 of the ECHR. However, inevitably, doctors are going to be consulting with their colleagues, and certainly we would make no effort to impede that. In relation to whether or not Ireland may face a challenge in relation to denying abortion in cases of fatal fetal abnormality, certainly we think it is very likely that such an action would succeed. And in those circumstances, yes, I'd absolutely endorse the position set out by Senator Bacic that rather than waiting until that happens, we should be actively seeking to improve our Article 3 compliance by providing for abortion in cases of fatal fetal abnormality now. In relation to Senator Bradford's question, I would first clarify While we are very clear that we are a campaigning organisation with a position in relation to this, we've come here today as a body that also has very substantial expertise in relation to human rights law, and that's the capacity in which we've come here today. And so our analysis, and I hope the analysis I've given to date, has been very heavily focused on the constitutional rights law and the human rights law of the ECHR, rather than a separate political campaigning organisation. But I thank you for your comments in relation to that. In relation to the requirement under Article 8, Ireland is under a positive obligation to provide an effective, accessible procedure. At the moment, there is legislation from 1861 which says it is a criminal offence to perform an abortion. The difficulty is that if that wasn't there, perhaps it could be done by guidelines, perhaps it could be done by statutory instrument. But the fact that there is extant legislation which makes this a criminal offence means that the only thing that can remove that sword of Damocles, as it was recently described by a senior doctor, is legislation to repeal and replace that. We would also be strongly in favour of the idea that effective and accessible mechanism should be at the statutory level to ensure consistency. Now, we would endorse the view of a statute plus a statutory instrument plus regulations, because obstetric medicine is developing all the time. At the moment, our legislation is 152 years old. Obstetric medicine in 1861 was entirely unrecognisable from what it is now, and so provision for flexibility there, I think, would be something worth endorsing. In relation to, my apologies, I think it was Senator Walsh, and mentioning the C case and the cancer case. I had made reference myself to the C case. I was making reference to an Irish High Court decision, which is also rather unhelpfully referred to as the C case, which involved a 13-year-old rape victim. But in connection with that, the concern there was not what was medical practice in Ireland. The concern was not about doctors making decisions. The concern was the woman had a constitutional right, and she needed to find out whether or not that constitutional right arose. It was not, the difficulty is not with the medical practice. The difficulty is with accessing the right. And again, people don't have to justify accessing rights. That's why they call them rights. And the constitutional right was very clear there. The difficulty was she had no means in which to access that. In relation to your concern around diagnosis of... I'm going to finish my answer to your question, if you don't mind, Senator. In relation to your concern in relation to diagnosis of suicide, the Supreme Court rejected in the X case the position that had been taken in the High Court, which is a requirement of an immediate risk. The test that is set out is real and substantial risk to life on the balance of probability that can only be avoided by termination. In circumstances like this, we are dealing with life and death situations that to some extent involve predicting future human behaviour, and we are relying on the best judgment of our medical professionals. Certainly our view is that we should trust them. And within the rubric of that test, sometimes they will get it right, and sometimes perhaps they may get it wrong. But again, the test that is set out does not require absolute certainty. It requires probability that there is a real and substantial risk to the life of the mother that can be avoided by termination. So again, the constitutional position under the X case is very clear. I think we should trust our doctors in relation to that. In relation to Senator Healy-Eames's concern around the decision upon having medical advice that a pregnancy is not viable, the decision on whether or not to terminate the pregnancy. I think it is very easy to look at situations in hindsight. This comes back to what I was saying about we are trusting medical professionals to make difficult situations about future events. I think the key thing the Irish Council for Civil Liberties would think in that circumstance is the decision should be made by the woman. And certainly this is something that is emphasised in the expert group report in relation to the test under the X case in the principles set out in Chapter 5. At the moment, the woman doesn't make the decision under Irish law. The decision is made by an 1861 criminal statute for her. And so I think we have to trust women in that situation. Some women, I have no doubt, will carry the pregnancy to term, and perhaps the child might survive, I don't know. But even circumstances where it is clear that the child is not going to survive, some women may decide to go to term in any event. Some women may not. I don't think that that is a decision should be made for those women. And I have real concerns under Article 3 that the Irish state seeking to make that decision for women who are faced with a clear medical diagnosis that the pregnancy is not viable, that there is a real risk that will be found to be in breach of Article 3. In relation to Deputy Tobin, as I've indicated already in relation to the question from Senator Crown, the Irish Constitution distinguishes between the right to life of the unborn and the right to life of born people. That is a distinction that arrives from the Irish Constitution itself, and I don't really want to go beyond that. In relation to Senator Murku's question, again, we are here today to provide the benefit of our expertise in relation to constitutional rights and human rights. In our analysis, we have, of course, been cognizant of Article 40.3 throughout. We are of the view that in cases of rape and incest, in cases where there's a substantial threat to the life of the mother, that ultimately it may be necessary to provide an abortion. And we are in favour of that as a campaigning organisation. We are not saying at the moment that the European Convention on Human Rights requires that. In relation to the European Convention on Human Rights position, and again, this is something that's considered in detail in cases like A, B and C, in cases like Tisuch, whereby the court says, look, there is an emerging consensus among the Council of Europe member states in relation to abortion. The vast majority of Council of Europe member states provide for relatively liberal, certainly relative to Ireland, abortion regimes. At the moment, the position being taken by that court is that it falls within the margin of appreciation for a state to determine how it governs its abortion regulation itself, in circumstances where Ireland has this constitutional right. However, it has failed to meet the Article 8 obligation. However, I don't think we can discount the possibility that that consensus is changing over time. And so I think we need to be live to the fact that ultimately the development of the ECHR case law in this may begin to indicate that if we are looking at, say a young rape victim who is not suicidal, but who is asking for an abortion, in those circumstances, I think it's entirely feasible that ultimately the ECHR may determine there's a violation of Article 3 to deny. That has not happened yet, and I want to be very clear. I'm not saying that it has happened yet, but I think in drafting legislation, which will hopefully be in place for some considerable period of time, it is extremely valuable for this committee and for these houses to have one eye to its human rights obligations internationally.
Thank you. Okay, the hearing stands suspended until... Sorry, before I finish, just to thank Dr. Brady and Mr. Hare for coming in. And just to say we stand suspended until 14:45.